Hi, everyone, and welcome back to Business Ethics. So for this module period, we're going to continue talking about corporate social responsibility. Last week, we identified who shareholders are and stakeholders and the sorts of general obligations that exist between the two. And we roughly came to the conclusion that some things need to be done when it comes to corporate social responsibility. And this week, we're going to start looking more closely at what those obligations really look like on the shareholders' end, on the manager's end of things. So we will get started. All right, so one of the first things to bear in mind when we are talking about corporate social responsibility is the specific system that the United States operates within. So just as a sort of heads up, we're just going to be sort of defaulting into the current system we have in the United States to talk about some of these ethical issues that arise when we're talking about thinking about all of these different things that relate to this big bear of corporate social responsibility. So, and obviously the United States is not the only place that has limited liability corporations. However, we're going to be speaking about it in the framework that those corporations exist within in the United States. Okay, so one of the first things that we need to think about when we're asking what sorts of obligations do shareholders have to the rest of society, right, is, exactly what sort of entity those corporations are. And in the United States, we have what are called limited liability corporations. So what are limited liability corporations? Well, the textbook defines it, and this is a great way to understand it. Shareholders being all of the people that are putting money into the business. So this is going sometimes to include owners of the business, to some extent managers, people that are higher up in the decision-making process about what the corporation does, how it allocates its resources, these sorts of things. So those individuals, which can be shareholders, managers, directors, etc., are protected by laws such that losses due to a business's failure cannot exceed the amount they paid for their shares of ownership. What does that mean? Well, I think a lot of you already know this. My guess would be perhaps even all of you already know this, but what that means is if a company files for bankruptcy, say it goes, things go south, the company's going to be shutting down. That what the company is going to owe to perhaps employees in terms of like severance benefits, these sorts of things, but also to the government creditors, all of this is going to be limited to it's going to be limited by what they put into the business, meaning that the governments, if someone files for bankruptcy, say they owe a bunch of money to creditors or back pay to employees. There are certain limitations in place where oftentimes they say the court rules in the favor of the employees or the creditors or something like this. The damages that people can seek are not going to go into, say, the shareholders' bank account, right? Or that won't be pulled from a shareholder's individual or private bank account. That the amount of money that they owe is the extent to which they invested in that business. So it's complicated, as I'm sure many, if not all of you are aware. There's a lot of different ways that work, but roughly understood, the purpose of an LLC is to keep the economy healthy by granting certain protections to facilitate economic investment. So what that means is it's trying to, the existence of LLCs is trying to encourage participation in the sorts of activities that are thought to keep our economy in the U.S. Especially healthy, right? Because in order for it to keep functioning and going, we need to have investment. Businesses need to acquire capital, and all of that is ultimately within the control of private companies. So you might say that industry and trade in the United States is controlled entirely by private businesses, and LLCs keep everybody active, keep everybody participating in the economy, keep that flow going, which is thought to keep the economy ultimately healthy. All right. So the benefits, which, what I've just said, probably this is related, but to be explicit about it, what the benefits are specifically for shareholders is this allowance for a socialization of losses. So the textbook talks about what socialization means here a little bit, namely being that if a company goes belly up, then provided that that company is an LLC, the losses that that company feels is spread out across society. So they're not going to have to bear, individual shareholders aren't going to have to dig into their personal bank accounts to make up for whatever losses are incurred in terms of like what they owe, things like this. That's something that ultimately gets spread out across our society in the United States. Okay, so that's basically what a limited liability corporation is. That's the purpose. Those are the obvious benefits. So one thing we want to think about now is, in light of the sorts of benefits that are afforded to LLC, what obligations might we want to say that a particular LLC has to the society it exists within? So one important thing to bear in mind when we're sort of trying to tackle that question is that society enables these corporations to exist. It enables LLCs to exist, right? LLCs is a defined legal category. It's a recognized individual entity that's afforded certain benefits and rights, right? So, and that's something that is brought about by virtue of us voting people into public office and those publicly elected officials passing various forms of legislation. And, our legal system, court rulings, things like this, laws passed within individual states and on a federal level, all of those sort of function as various versions of this same recipe that give rise to laws that recognize the existence and protect the rights of these limited liability corporations. And sort of built into those laws, built into what we say an LLC is, what we define that to be, how we sort of create that entity on a social level. Built into that are limitations concerning the financial risk of exposure to the people that own the companies or the people that invest in the companies, right? Because like we were saying, or I was talking about on the previous slide, encouraging that kind of participation, to get people wanting to invest in companies and keep these companies going, and promote innovation and new companies coming out with better products, ideally, and keeping a nice healthy competition running between different companies and industries that offer competing services and things like that. To keep that going, we don't want to, or rather to keep that going, we want to encourage people to be investing that sort of capital to keep that healthy flow in the economy going. And one way to really encourage that behavior, right, is to limit the kinds of risks that a person takes on when they invest in a company or when they start a new company. So with those two things in mind, namely being society creating this category of an LLC, which allows LLCs to exist, and the rights that are built into what belongs to that category, the rights of those individual entities, bearing in mind that those are things that that society sort of brings into fruition. What one could argue is that there is a sort of quid pro quo between LLCs and the societies that they exist by virtue of. So quid pro quo, probably a term that many of you have heard. It just means this for that. So I give you this, you give me that. So one might argue that given this point here, society enabling corporations to exist, giving them these kinds of rights, that it gives rise to an obligation between society and these LLCs. So one could argue that an LLC, since an LLC is allowed to make these unlimited profits, incurring limited liability, right? So because we sort of decrease the risks involved in that opportunity to make unlimited profits, corporations owe a debt to society in return. So one could say essentially that there should be a quid pro quo between society and these LLCs, right? And that isn't to say that there are any specific obligations yet here. It's just the sort of baseline on which we might argue that, there are some things beyond maximizing profit that a corporation, an LLC, is morally obligated to do, because if it weren't for society, then LLC wouldn't be wouldn't have the opportunity to make unlimited profits with limited liability. Okay, so what are these moral obligations exactly, right? Because I'm sure a lot of you are thinking, your brains are turning over right now, like, well, does that mean that they are morally obligated to give a portion of profits to charity? Does this mean that they are morally obligated to provide healthcare to employees? Are they morally obligated to ensure that the individual communities they exist within are really thriving and doing well? Or is it, merely just a matter of they're morally obligated not to break these laws, these sorts of things? We have a very wide range of things that a corporate social responsibility might consist of, right? That was something that was talked about last week, where Milton Friedman's view on, essentially thinking that there had to be some kind of donation made or loss of profits as a result of a corporate social responsibility initiative. As we saw, that's not necessarily the case. There's a lot of different ways that a corporate social responsibility may manifest. So with that really broad scope of things in mind, we're going to kind of narrow it a little bit and look at mainly just sort of what the law tells us about what these moral obligations might be. So, so one thing that we could say, one just like very single narrow argument one could make to support that quid pro quo idea here, or the argument here, is, okay, listen, society and our laws enable LLCs to exist. They give you these opportunities to make a bunch of money with limited liability. So at the very minimum, corporations are morally obligated not to break the law. I think that, that counts as a corporate social responsibility. That's a responsibility that that a corporation has to the society it exists within. So at the very least, we have one corporate social responsibility that we see. It doesn't really matter, and it doesn't necessarily require that a company loses profits in order to not break the law. But even if it did, we have a pretty good example there. Well, it doesn't really matter. Society is the thing that allows you to exist. So don't break the laws of society, right? That's seems like a pretty obvious, not controversial claim to make. Okay, so we have these. So now at the very least, what we can say is, well, corporations are morally obligated not to break the law, right? Okay, so now if we accept that, then we want to say, okay, so what is it? What kinds of laws are going to constrain or guide or shape the kinds of responsibilities that corporations have? So while we have this bare moral minimum for companies to, or rather LLCs, to not break the law, there are also laws in place that protect these LLCs. So it's not just like I was saying, we have these laws that make it possible for LLCs to exist. Within those laws, there are certain rights and then sometimes obligations that LLCs have. One of the rights, so if we think of an LLC as an individual, right? One of the rights that they have are, or rather concern, fiduciary duty, namely being the kinds of things that managers, directors, CEOs, even business owners owe to shareholders. And oftentimes that's something that comes in the form of maximizing profits, right? So there's a duty, say, for a manager or a CEO or a business owner to maximize the profits. That's a duty that the business owner, CEO, manager, what have you, has to the people who invest money into the company, and a fiduciary duty it may not be simply maximizing profits, but in some way it is pursuing the interests of a corporation and the shareholders, or the shareholders of a corporation's best interests, and placing those before the interests of everyone else. So one thing that might be involved with this sort of fiduciary duty would be taking a certain interests of certain shareholder interests, and placing them prior to, say, maybe the interests of the employees who work for the LLC. Okay, so while there are laws that we're going to talk about shortly that most certainly protect that fiduciary duty that managers have to shareholders, that doesn't, just because there are laws that protect the fiduciary duty, that protect this fiduciary duty, it doesn't mean that that's the only thing that a manager owes, right? Because, like we were talking about just a moment ago, at the very least, they owe it to society, not to do things within the company that breaks the law. And something that we're now, so once we have those two things in mind, we can sort of start to think about more about this question of what does a corporation owe, or rather, does a corporation owe a duty to society or only to the shareholders, right? So just a moment ago, I pretty much gave an answer to that question, where there's at least a pretty good argument that can be made, answering no and saying that that it doesn't only owe a duty to shareholders, it at least owes a duty to society insofar as it won't break the law. Okay. So with these sorts of constraints and rights, right? So we have like some obligations not to break the law, but then we also have these rights concerning fiduciary duties in mind. What we're going to do now is we're going to turn to sort of what the legal framework looks like for these, for what exists between those two things. So we have the bare minimum, not breaking the law, right? And then we have these fiduciary duties. So like, what are the obligations in the middle? What do they look like? What does the law say about that, right? Because like I was talking about on the previous slide, society enables corporations to exist by passing certain laws. In a way, society sort of decides what an LLC is, and what sorts of rights and obligations it has to society. So it sort of colors in the picture of what an LLC is and what kind of rights it has, existing as this individual entity. So before I talk about that piece, I wanted to just briefly talk about how we're going to, or rather sort of give you a way to sort of conceptualize why we're talking about these Supreme Court cases here. So like I just mentioned a moment ago, we as a society, by virtue of democratically electing certain people into office, who then in turn, create legislation and things like this. And then also those electing people who then elect people into positions like judges on the Supreme Court, or on a state or federal level. And ultimately, the actions made by legislators and judges, as well as executives in the government as well. But there are things that they do, decisions they make about the law, how the law is going to be interpreted, that sort of fill in or color and shape what an LLC is and what it's morally obligated to do. And one thing that is really easy to forget when we're sort of thinking about the role that court rulings play in this coloring and line drawing of individuals and rights and things like this. So not even exclusively for LLCs, but just in general, when we sort of like invoke some kind of Sullivan v. the New York Times, the court ruled da 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 da. When we're talking about things like that, one thing that we want to bear in mind is that decisions that are made about how the law is interpreted often change, in large part because language in legislation, as well as in the Constitution and its amendments, is often, unfortunately, it's sometimes vague, meaning that it could mean a bunch of different things. For example, our constitutional right not to receive cruel and unusual punishment, right? So the term cruel and unusual is notoriously vague. Really, it could mean so many different things. Versus there's just ambiguity. There are laws, for example, concerning, you're not, there are certain kinds of punishments that coincide with using a gun to commit a crime, right? So using a gun to commit a crime, that might mean firing it, using it as a weapon, but sometimes guns are used as in a form of exchange too, right? So people might use a gun as a form of currency. So there's a little bit of ambiguity in the term, what it means to use a gun, right? So when these sorts of things happen, when there's a case that crops up where there's an ambiguity or vagueness in a law, judges are the ones that dictate how the law should then be interpreted. And oftentimes that really shapes what constitutes following that law, and what sorts of obligations we might have not to do certain things, because doing those things would be tantamount to breaking the law, right? So what happens in Supreme Court rulings on a federal level in particular, and that's going to be in the cases that we're going to be talking about shortly. Those types of rulings have when they set precedent, there are some pretty serious consequences to it. And we might want to feel like, well, as soon as there's a certain ruling on a particular piece of legislation or problematic interpretation of the law, once a federal Supreme Court rules on it, great, it's end of story. There's no more debating about it. And as I'm sure a lot of you are aware, that's not really, although we want to maybe feel like there's some kind of like expert consensus that'll be brought about, and then it's really clear what, say, our right to free speech consists of. That's not necessarily the case. Oftentimes what ends up happening is there's going to be some kind of interpretation or ruling made about the way that individual or states' rights are constrained or not allowed to be constrained. And then years on down the road, that precedent is appealed to by current Supreme Court justices to then sort of elaborate on a new set of constraints or a new set of rights. And as a result, when we have a particular opinion about how we think, say, our right to free speech ought to be understood within the eyes of the law, and say we might find a particular case where we say, what, that person, they're claiming they're allowed to do this thing because they say it's their right to free speech, but I don't think that they should be doing it, right? We want to think about what sorts of consequences might happen down the road if the Supreme Court ruled in agreement with our position. So for instance, in the example of free speech, one of the most, or a landmark recent case that really has shaped what our free speech rights consist of, was a ruling called Sullivan v. the New York Times. And in that case, ultimately, it was a politician that was saying that the New York Times published false and defamatory information about them. So what the Supreme Court ruled there was that the private, or not a private citizen, but a public citizen has to prove that a publication intended malice when they published false information. And that is a very, very, very hard thing to prove. And consequently, it has made it a lot easier for different publications now, including on the internet, just to publish something that's false, to say something that's false, and then not get in trouble for it later. So see something false about a particular person's view, something that they did or something like this, it's really easy for the most part to say, to sort of, at the worst, feign ignorance and at the best say that they didn't, adequately sort of, it was an oversight or an error on their part, but there's not a whole lot of there aren't many consequences at the very least in terms for publishing false information about a person. And that court ruling has allowed for a whole host of problems. I think a lot of you are probably familiar with the problem of misinformation on Facebook, right? Different news outlets are able to report quite a bit of false information without much consequence. And that widespread dissemination of false information is proved to be a pretty big problem for our society. So we might think like, okay, well, maybe we need to revisit court rulings like Sullivan v. the New York Times and other major landmark cases that really, significantly strengthened free speech rights of news outlet organizations. And currently, there are several Supreme Court justices who have expressed interest in revisiting specifically that case, which means that we might end up with a much different version of what our free speech rights are. In particular, what consequences might follow or laws can be made against publishing false information, even if perhaps an organization didn't realize that the information it was publishing was false. And while there seems like there could be some really great benefits to it, I'm sure there are plenty of people in this class right now thinking, oh no, this could lead to some like pretty serious and scary censorship of organizations if we make the burden too great in ensuring that information they're publishing isn't false, or at the very least, if they're publishing information where it's not really clear what's false and what's not, right? So with that kind of understanding in mind, just like namely being the kinds of implications that come with these rulings. And with each ruling, we could sort of think of each ruling concerning a set of obligations and rights of an individual, and in our case, and in the case of, on theme for what we're talking about this week, for LLCs, each ruling kind of shapes and colors in the what the legal obligations and rights that a particular entity has, or a particular LLC has. Okay, so for one of the big things we want to think about when it comes to sort of identifying, obligations and rights of LLCs is we want to think about to what extent, right? So if we're thinking about corporate social responsibility and we're thinking about resources, LLC's resources being spent on, satisfying some kind of what is taken to be a moral obligation, right? So this isn't necessarily a legal obligation, important to bear in mind. This might be above and beyond. This might be going beyond the bare minimum, not just not breaking the law, but somehow helping society in some kind of way. Allocating those resources, making those kinds of decisions, those kinds of managerial decisions, right? And, the extent to which that is allowed to impede upon or sort of diminish fiduciary duty to the manager's fiduciary duties to the shareholders, right? The duty to maximize profits of a business. So in the first case, the text talks about Dodge v. Ford Motor Company. Essentially, what was going on there was the owner of Ford wanted to spend money on doing things for employees, and that money was essentially pulled from, or rather Dodge claimed that shareholders of Dodge claimed that money was essentially taken from shareholders, right? So here, what we're looking at here is like, okay, so we have a corporation clearly doing something, the owner, Ford, feeling like he had a corporate social responsibility to employees, and he decided to take some of the profit in the company and pursue that responsibility, or invest that in a CSR initiative. And the shareholders said, hey, wait a second, that money's coming from us. Your duty, you have a fiduciary duty. We come first. You don't have a right to do that. And what the Supreme Court ruled in that case was that Dodge was right, that Ford had his fiduciary duties came first. Those interests of the shareholders were prior to the interests of employees. Ford was obligated, legally obligated, to put profits first. So in this case, what we have is the government is saying, all right, so while I'm shaping and coloring in what this LLC is, the kinds of obligations and rights I have here, shareholder rights need strong protection. And the extent to which any corporate social responsibility initiative is implemented, really, whatever is done here must be done at the very least with the permission of the shareholders. Okay, so it's a significant strengthening of shareholder rights, and somewhat diminishing corporate social responsibility, namely to the employees. Okay. Then in Shelensky versus Wrigley, we see a Supreme Court decision move that goes in the opposite direction. So in this case, we had, it was the owner of the Chicago Cubs, where the Cubs played in Wrigley Field. They wanted to put, the shareholders wanted to have lights installed at night, so people would come and pay to see more games, right? That would make them more money. And the owner of the team, Wrigley, said that he did not want to put in the lights because the community that Wrigley Field existed within didn't want a bunch of lights at night. For a number of reasons, the textbook said that it had to do with like concern about increase of crime in the neighborhood. That's probably partially right. I think that there's probably a lot to pick apart there, what the motives were involved. But in any case, we have the interests of this community that a corporate entity exists within, right? So we have Chicago, and then we have Wrigley Stadium. And here, what the Supreme Court says is that Wrigley had the right to put the interests of the community that the corporation existed within ahead of the interests of the shareholders. So there, the Supreme Court really flipped its sort of take on what rights and obligations an LLC has, right? So it shifted the lines and kind of changed some of the coloring of an LLC, saying that, okay, actually now you can have owners of companies or potentially even managers that, like I said, the way that these rulings work is they set a particular precedent and then it can be taken up and argued for in other contexts as well. But this opens the door up at the very least to even managers, making decisions that ultimately make the company less money, but are thought to be good for society, good for stakeholders, communities that corporations exist within, employees, et cetera. So like I said in the brief little sort of intro to talking about how we understand the way these Supreme Court rulings work, oftentimes precedent like that is picked up and run with. So now, more recently, we had another case involving Hobby Lobby, where the company didn't want to, the company was required to do certain things under the Affordable Care Act that it didn't want to do, specifically in its healthcare provisions for employees. It didn't want to give women access to any form of birth control. And the argument that Hobby Lobby made was that, hey, listen, we're an LLC. In a lot of ways, we're considered individuals, right? And as individuals, we have a right to exercise freedom of religion. And according to our religion, our company was founded on a specific set of Christian beliefs. I think it's pretty important to recognize this is not all sets of Christian beliefs involve limiting women's access to birth control, but for like Hobby Lobby's specific set of religious beliefs, they claimed did. And consequently, they said that they shouldn't be required to do this thing that the Affordable Care Act said that they are legally required to do. So here we have even a more extreme instance of a company, or rather an LLC, saying that they should be able to put a corporate social responsibility not only ahead of profits, but to some extent ahead of the current legislation in place. So on their view, they had a corporate social responsibility to uphold their Christian beliefs, their specific set of Christian beliefs, and freedom of religion, because they're being in this category of an LLC puts them in a position where they argued that they like individual citizens, for the most part, of the United States. In the same way, those people have rights to to exercise freedom of religion, as so do the owners of this particular company, and that being forced to essentially provide a service to employees that would compromise their ability to exercise their religion. They say that that impedes upon their ability to exercise freedom of religion. So in that case, again, the court ruled, and also it's worth noting, cited Chalinsky versus Wrigley in favor of Hobby Lobby, saying that under those particular circumstances, that Hobby Lobby, the managers or the owners of Hobby Lobby, these like the small sect of people that are like running the operations of Hobby Lobby, are allowed to or that not all necessarily any law that impedes on their ability to exercise on the company's ability to exercise freedom of religion is not a law that Hobby Lobby is legally obligated to follow. So it's a sort of exception in that case for following the law. So one thing that we want to think about here, just in terms of, like I was saying, setting precedent and then trying to imagine all of, the best and worst case scenarios for where that kind of precedent can be applied. Something the Hobby Lobby case in particular should make us really start to think about is, okay, so now we're really, we've drawn some pretty hard, thick lines. It would be hard to erase some of these lines, right? The more a precedent like Shalensky versus Wrigley is upheld in a case like Hobby Lobby, the thicker and heavier that line is, the harder it makes it to erase it. And we're coloring in some pretty intense bright colors here for what constitutes an LLC and the kinds of obligations and rights it has to exercise things like freedom of religion, right? What we want to then turn our attention to is say, okay, so maybe in this case, for instance, this isn't necessarily to say, assume that all of you agree or disagree or whatever, but let's just assume someone who agrees with Hobby Lobby in this case, agrees with the Supreme Court ruling, what they would then want to really seriously think about is how that ruling concerning the rights of an LLC intersects with anti-discrimination laws, right? Because, and the chapter doesn't discuss this, but around that, I believe it was around that same time period, there was at least one big Supreme Court case. I don't know if it was an LLC, but in any case, there are companies that are claiming that, given it's the set of religious beliefs that a business owner has, that they, don't want to make their services available to individual groups, like, say, gay people. So there was one big Supreme Court ruling around the same time where a wedding cake company refused to make a wedding cake for a gay couple who was getting married, and the couple sued the company on grounds that it broke a number of anti-discrimination laws, and again, the Supreme Court ruled in favor of the company owners, saying, yeah, this impedes on your freedom to exercise religion and to voice opposition to the existence of gay people. So, now we want to maybe think about the kinds of sets of religious beliefs a company may claim to have that is fundamentally exclusionary in nature, right? So not just thinking about gay people, but, thinking about people, Black people, Indigenous people, disabled people, various things, groups maybe that it's a little bit where, we really see we have legislation, anti-discrimination legislation in place in order to protect the rights of these people, because oftentimes those are people that are find themselves in positions for various reasons that, their safety is a serious issue, or just, just other clearly unjust positions that they find, or injustices that they find themselves regularly facing. And we have those laws in place, vote people into office to put those kinds of laws in place, and vote people into office to put judges in positions where they're going to make rulings that are supportive of people that are in need of those additional protections, right? And then that is something that can come into conflict if we start affording these organizations, maybe less so for the wedding shop, the wedding cake company, but clearly in the case of some place like Hobby Lobby, a big chain store, right, who's impacting a lot of people, engaging with a lot of customers, employing a lot of people, those sorts of things. So when we think about how, that those kinds of rights and obligations, or rather the rights more specifically, that have been pretty drastically strengthened, how those rights might then later conflict with anti-discrimination laws that we would also really want to be followed, that's when we want to start thinking, okay, so do we need to pull back a little bit on a company's or an LLC's right to exist as this entity that exercises a right to free speech or a right to exercise freedom of religion and things like this. So that's where while we're sort of thinking about the rights and limitations that the decision makers for a corporation have to do things that impact the profit of the company, we might want to we might have started off saying like, oh yeah, we want to put protections in place for we want to require a manager or business owner, someone like Wrigley, to like really take seriously and prioritize the interests of the communities that they exist within, right? Like that sounds like a really good thing. But if we end up in a position where we go all of the way to, well, yes, and in the implementation of like essentially, since we're not able to really constrain what a small group of decision makers in an LLC deems something that needs so individuals and managers of companies to decide what kinds of corporate social responsibilities or corporate social responsibility initiatives they want to take, right? So since we can't define what that is, when we strengthen the rights of that small set of decision makers to pursue whatever corporate social responsibility they want, we need to think about, these like more extreme instances where given the status of being an individual, or given an LLC status of being an individual, the more we strengthen those rights, the more it looks like those small group of decision makers could exercise further rights, like the ones that private citizens within the United States have. So like freedom of speech or freedom to exercise religion. Okay, so that is, so that's roughly sort of what we're thinking about, the legal realm, the legal obligations and rights that that LLCs have with respect to their corporate social responsibilities. So that's sort of that's going to be what we're going to the extent to which we're going to be talking about those things in this class. So now, with a clear understanding of who stakeholders are, who the shareholders are, the kinds of obligations that an individual company has to those shareholders, as well as the kinds of rights and obligations that are afforded to LLCs by virtue of them existing as these limited liability corporations. So we're going to want to think, so with those things in mind, sort of hopefully that's colored in your understanding of these different dynamics involved between different groups, different needs that one group has, and, to what extent we want to say who owes who to what, and to what extent we want the law to dictate, how those different needs or rights are prioritized. We're gonna turn to a case study, or I'm calling it a case study, involving healthcare. So, for everything that we've talked about thus far, we're talking about baseball teams, cars, various manufacturing corporations, things like this. A lot of you have talked about restaurants and social media companies and things like this, right? So like thus far, that's kind of the gist of, and definitely some of you have talked about healthcare as well. But I think in large part, it's more on those sides of, it's more that theme of LLC that we've been discussing. And so it's one thing when we're talking about, buying tickets to go see a baseball game, or, the kinds of obligations maybe like a particular app has to consumers and shareholders and things like this. But I think that there's just an intuitive difference between those kinds of businesses that operate within this economic system that we exist within, right? Like I was talking about in the very beginning of the lecture. It's a difference between that kind of LLC and LLCs LLCs within the industry of healthcare, right? Because healthcare, as we've, I'm sure, all learned in the pandemic, and I'm sure I know for a fact many of you prior to that were very, very much aware of, healthcare and access to it is seriously complicated, and especially in this company. So, or in this country rather. So within the United States, the textbook talks about this. I'm sure everybody here is aware, we have what's called a multi-payer healthcare system versus a single payer healthcare system, right? Like you would find in Canada or in the UK and a lot of other places where the government is solely responsible for acquiring essentially one big old healthcare plan for all of the people in the country. So here what we have is we have a bunch of different individuals that end up paying for healthcare. Right, it falls on the individual for the most part to pay for their healthcare. Obviously, there are some government funded programs and things like this, but in general, healthcare is something that you have to acquire on an individual level in the United States. And there are definitely benefits to that. The textbook talks about those. But like the last part of chapter 9 discusses, there are some pretty serious ethical issues. So what I'm going to have us do for this last little bit of the lecture is just think about these issues in light of some of the things that I was talking about earlier just now, in terms of shareholder primacy and LLCs. Okay, so one of the first, or perhaps maybe arguably one of the most notable issues that arises with our healthcare system is because the government isn't the one that's essentially buying one big healthcare package for everybody. The burden of paying for prescription medication falls on the government. Essentially has a lot less control over, pricing of prescription medication, often cases life-saving prescription medication. And the burden of fluctuating costs, often like drastically increasing costs, something that falls onto the consumer. So there are obviously, or rather not obviously, but I'm sure many of you, and I know several of you actually have mentioned examples where a company price gouges the cost of certain medications. And in the video that we're going to watch now is an interview. Or rather, it's during a hearing, one of these instances where a company drastically increased the price of medication for a much needed cancer medication. It was a highly effective medication to treat cancer, something that had been around for a really long time, something doctors were really familiar with, had a lot of experience working on, a lot of research done, ensuring the effectiveness of it and these sorts of things. And there was a massive price hike in the cost of the medication. I think between, you're going to hear the numbers in just a moment, but in the period of, I think, less than 15 years, the price of the medication quadrupled almost. And yeah, in this, so as the textbook talks about, and hearing's going to touch on in a moment, this is often justified by companies arguing that, this is how we sort of generate more money to invest in researching new medications, right? So this is supposed to be something that's for the benefit of the consumers, right? But and to some extent, I think that that makes sense. I'm sure that there's plenty of people in this class that are sympathetic to, needing to like raise that kind of capital. But at the same time, this particular drug, this isn't the first time that we've seen these drastic price hikes. There was one, I think a couple of years ago, there was a company that tried to do this for insulin. They tried to, drastically, it was, I think it was something along the lines of like 500% price increase for insulin. And, a lot of people die if they don't have access to their insulin. And ultimately that was something that the company, it dialed itself back on. But there are other people, the infamous Martin Shkreli. I'm sure that many of you are familiar for a number of reasons. He is in jail for participating in a pyramid scheme, but when he was running a pharmaceutical company, he wasn't ever found guilty of this, but he did, I think it was like a 4,000% price hike for another medication. It was actually a pretty small group of people, and it was a life-saving medication. So while there's most certainly an argument to be made that kind of those price increases for the sake of generating capital is something that is necessary for like innovation and further research. At the same time, we have instances where, these massive price hikes, like you've really got to start to question the extent to which a company really is doing that for the sake of research, or whether they're doing that in order to maximize profits. And so while this hearing is going on, I think one really important thing to bear in mind is, like I was talking about before, healthcare and the companies that support that industry, or that constitute that industry in the United States, clearly is healthcare is something that people rely on in order to survive, right? We have like incredible access to technology and drugs and things like this. And while, somebody wouldn't need to necessarily argue that everybody deserves like total unmitigated access to all the absolute best medical services, although, somebody can make that argument, but you wouldn't even have to go that far to say like, well, I think that there are some things that we need to do to constrain the kinds of rights that a LLC has to maximize profits, because its obligation to society is one such that if it decides to just focus on the fiduciary duties, many people will die. So that ultimately, and, without giving a full-blown argument as to saying like, well, that's it, like the healthcare industry, that's its own, bag of corporate social responsibility worms, right? Without giving a full argument there, I think at the very least, it's reasonable to assume that some of those obligations might be a little bit different, just even at the very least, because it's one thing to not be able to say, purchase a particular app or a pair of shoes or something like this, but it's quite another not to be able to access insulin because a company wanted to increase capital to research some kind of new drug. Those are at the very least two different kinds of moral concerns. Those are two different kinds of moral issues. So bearing that in mind, we're just gonna watch this hearing. This is with this is a state representative for California, Katie Porter, who is interviewing the CEO of this company that had just implemented a pretty drastic price increase of this cancer medication that has been around for a really very, very long time.
Know what the price of Revlimid was when it first hit the market in 2005?
I don't remember the number, but it was 200 or...
Reclaiming my time. It was $215 for one pill. Do you know what the price of Revlimid was in 2013?
I can look it up, but I don't recall. I don't have it in front of me.
$412 per pill. How about the price? Let's get into more recent where your memory may be jogged. How about 2017?
I would say approximately $700 a pill, but I don't have it in front of me.
$719 per pill. And today, Revlimid costs $763 per pill. I'm curious. Did the drug get substantially more effective in that time? Did cancer patients need fewer pills?
During that time, the development of Revlimid included 6 additional indications, some in lymphoma, and the balance in patients with different segments.
Oh, great. I want to reclaiming my time. So, Mr. Ellis, you discovered more patients who might benefit from paying $763 a pill, but being able to use a drug for more patients doesn't necessarily more price. Did the drug start to work faster? Were there fewer side effects? How did you change the formula or production of Revlimid to justify this price increase?
The indication changes are for subsets of different patients with disease.
Reclaiming my time, Mr. Ellis, I understand that. What I'm trying to understand from you is how did the drug improve? If I were to look at a pill and analyze it from 2005, when it cost $215, and I was looked today at when it cost $763, would that pill be the same?
I understand your question about the pill. The manufacturing for it would be the same.
Great, thank you. So to put that in perspective, you hiked the price by $500 when the average Orange County senior only has $528 left in their bank account after they've paid their basic monthly expenses. The average Orange County senior can't even afford one pill. And you said recently that nobody pays the list price, but that is not correct. Do uninsured patients sometimes pay the list price?
I can imagine there are circumstances where underinsured or uninsured patients would be paying close to or at the list price. I don't know of any specific circumstances, but I would guess that they do exist.
I want to turn to one other number if you would help me. Do you know what this number is? Does it ring any bells?
But I think you're referring to my compensation in some way.
Yeah, well, in some way. This was your compensation in 2017 for being CEO of Celgene. And that's a lot of money. It's 200 times the average American's income and 360 times what the average senior gets on Social Security. Now, of that 13 million, about 2.1 million came from your company hitting yearly earning targets. And more than half of the bonus formula was based on those targets. Any increase in the price of Revlimid would also increase your bonus by increasing earnings. Isn't that right, Mr. Ellis?
if revenues increased and expenses did not, then earnings would be enhanced. And
Thank you. Mr. Ellis, in fact, the Oversight Committee found that if you hadn't increased the price of Revlimid, you wouldn't have gotten your bonus. Mr. Ellis, do you know how much you personally received in bonuses over 2 years, the last 2 years, just because Celgene raised the price of this one drug, Revlimid?
I receive very generous compensation, but I don't know the exact number that you're referring to.
In fact, you personally received $500,000 personally just by tripling the price of Revlimid. So to recap here, the drug didn't get any better. The cancer patients didn't get any better. You just got better at making money. You just refined your skills at price gouging.
All right. So it's definitely that particular state representative is very good at laying out basic. She was a teacher for a long time, so she's very good at detailing basic information on a whiteboard. And I think we can see something that is, it should be pretty obviously morally troubling for us, right? So if we have this system where drug companies, pharmaceutical companies operate, say, in the same way that your average publicly traded company operates on Wall Street, what we find is that there are situations where there's incentive, not just for companies or rather shareholders to maximize their profits, but those shareholders incentivize maximization of those profits to managers like that CEO, in order to maximize their own profits. So they sort of help encourage satisfying fiduciary duties by offering these kinds of bonuses. And while that might be acceptable in a lot of contexts, there's something that should seem especially troubling about an instance where there's been a drug that has it's been on the market for quite some time. It's well researched. Again, doctors are familiar with it. It's something that a company has been able to really figure out how to produce a lot of, and to do that efficiently. So that would be a situation where, we have this treatment that's like really effective in treating various forms of cancer, right? And we have like a really good system for doing that. That's all of the things that we would hope capitalism would accomplish, right? Because that company manufacturing that particular drug is doing an especially good job at it, right? And ideally, what we would hope is that there would be some sort of further incentive to make that drug affordable for people. But within because of our multi-payer tax care system and the way that insurance works within that system, it makes it possible for a lot of companies to hike drug prices in that particular way, that directly place the burden of those costs on consumers, where because there are enough people that have access, say, to insurance, those who don't, it doesn't matter if they're not customers, right? So one thing that we really want to start thinking about seriously there is the idea that customers can exercise some kind of autonomy, right? Like when a lot of you have brought up examples where companies, you say, it's not good for a company to practice this, to engage in these obviously like discriminatory practices, right? Because it's not a good look on a public level. People aren't going to want to buy that product. Well, if you're a drug company and you're the only one that's producing this cancer-saving drug, people don't have much of another option oftentimes other than dying, which, because of the seriousness, right, that should all make us feel a little bit that again lends weight to this idea, well, maybe for everything that we've talked about, these rights and obligations for LLCs within the United States and, the reasons behind that, all of that, maybe things should look a little bit different for pharmaceutical companies. Okay. So that's one problem of how healthcare works in our country. Now, another problem, or there's a few more problems. So we also have just this general problem of employees, or a problem of relying on employers and incidentally shareholders for access to healthcare, right? So here, the way that we have access to healthcare oftentimes, because getting that just for ourselves individually is super expensive. The way it works here is that we can buy into these sorts of big package deals. So it's not a single payer like in other countries, but rather like a company can buy a package of healthcare for a group of people, sort of like buying it in bulk. And as a result of that being sort of the most cost-efficient ways for individuals in a multi-payer tax healthcare system to get access to healthcare, what that means is that we rely on jobs in order to have access to healthcare. So one of the things that happens, because those companies also have to be concerned about what their profit margins look like, right? Is they're not, if costs of a drug or something like this increase, right? They're not going to bear the burden of those costs, and nor are the companies that are, say, maybe wanting to invest in new research for new medications, right? Like they're not going to say, well, obviously it's gotten to a pretty extreme point now, but to some extent, I think that at the very least, if you buy in, if you feel like if you're a supporter of our current capitalist system, you can say, well, it makes sense for companies to need to maybe somewhat increase the cost of certain drugs, not make them inaccessible, but somewhat increase the cost of certain, drugs that have been around for a long time, very effective, widely used sorts of medications, to then later invest in other drugs. But as we can see, the extent to which those rising costs, the extent to which much higher costs should be some kind of burden that falls on consumers is a serious problem, because not only might that cause someone to forego, taking a medication that is necessary in order for them to keep living, but also just being able to buy into the insurance plans in the first place, those rising costs, and then sometimes costs that are associated with having to get a spouse or child put on your plan as well. Sometimes it's so expensive, people just choose to forego it altogether. I know plenty of people that have done that or are currently doing that. I'm sure everyone in this class knows at least one, has had an experience with at least one person who's been in that sort of position. So that is a problem, mainly with respect to, given the limitations that we want to say an LLC has, or rather, given the rights that we want to say an LLC has to maximize its profits. So whether that is a pharmaceutical company, an insurance company, or a company that is providing healthcare for employees, because there is this, fiduciary duty thing floating around in the background, ensuring that people have access to life-saving medication, it seems like that might be a burden that is a bit too heavy. It seems like those things might just sort of naturally conflict with one another. Now, interestingly, there's a sort of flip side problem to that, where in order to cut back on the cost of insurance for a company, so say in order to cut back on having a lot of employees that are needing to use a lot of parts of their plans, which could then increase the price that a company pays for a particular insurance package. Some corporations have chosen to implement these welfare programs. So it's okay, so in the long run, this is going to save all of us money. We don't see increases in the cost that we don't see increases in the cost of like our insurance package, a cost that we would then have to, pass on to you employees, like, right, like higher premiums, these sorts of things. So since we don't want that, why don't we start implementing some programs that are going to like help keep you healthy, right? Okay, so that might sound all fine and good initially, but first and foremost, a lot of the science that gets relied on in the development of these kinds of wellness programs, while some of it is like totally spot on, like smoking is increases a chance of somebody getting lung cancer. There are most certainly other things connected to like eating habits in particular, stuff like that, where there's really not enough evidence, or there's, if anything, there's evidence contrary to what a wellness program assumes in terms of like what counts as eating healthy. And, one big problem, regardless of all of it, is that when these kinds of programs are instituted, it doesn't just constrain what an employee does inside of work, right? Like typically we want to think, hey, okay, so it makes sense if a company says like, you can't smoke at work, right? Like there's like no smoking on the premises, right? But do we want to make a person's healthcare possibly contingent on them behaving in certain ways outside of work? Or if an employee agrees to participate within a wellness program, but doesn't do what they commit to doing as a participant of that program, does that give a company grounds to fire that employee? So if somebody's like, yeah, I'm going to quit smoking, I'm going to work for this company, I'm not allowed to smoke anymore. And then say they break down, they have a cigarette and a manager sees them. Technically, that's something that it might be written into the terms of their contract that a company is allowed to fire them over, right? So when those kinds of when companies are given those kinds of that kind of leeway, that kind of freedom to sort of like engage in these agreements between like the people who run an LLC, right? And the managers, namely, and like the employees, how far do we want to extend that kind of control over an individual employee's private life, right? Because under other circumstances, there's plenty of legislation that stops employers from firing employees simply because of something they do in their spare time, right? Like unless that thing is something that breaks the law, oftentimes it's really, really, really hard for a company to fire someone because they don't like what they're doing outside of work. It most certainly happens. And in plenty of cases, it doesn't happen because it's necessarily something that breaks the law, but just because a company, because their status as an employer gives them a lot more power oftentimes. So it's not to say it never happens. It most certainly does. I'm not denying that. But at least in a legal context, it's something that's supposed to be pretty hard to do. So that's an issue that comes up where it seems like a pretty good deal for everyone on the surface. Wow, we're going to really bolster the manager's right to pursue this corporate social responsibility to keep everyone healthy. Hey, everybody wins because we're all paying less for healthcare. And then we start to see later on down the road, whoa. Does that mean that we want companies to be able to really control what an employee does during their own private time? Because when companies try to implement those kinds of policies, not in connection to such welfare programs, there are laws against doing that sort of thing. So finally, the last thing that we're going to talk about, the last issue, is not one that comes up in the textbook, but it is one that is very much relevant to what we've been talking about today. And that is the basic fact that profit maximization for a company. So we're thinking about here, for the most part, people in the United States rely on their jobs in order to have access to healthcare, right? So we have that on the one side, just the given way our system is. And at the same time, like we were talking about in these other Supreme Court rulings, right? And for the most part, I think that there's a lot of popular support for, protecting shareholder rights, right? Like that, like I was saying in the very beginning on the very first slide, the purpose is to keep the economy healthy. We have these LLCs to keep the economy healthy, and built into the rights of an LLC is, at the very least, one of the obligations is to try to maximize profit. Now, as we saw in some of these cases, that's not always the case, but in large part, a lot of people feel that that's sort of the main that's the main thing that that a company or managers of a company need to do. Now, I won't spend too much time talking about this, but I think that it's something that's just sort of worth sitting on and thinking on. I think it would be good to think about some examples where profit maximization does not require having healthy employees. So for those of you who got all the way to the end of this video, if you would like to send me an answer to this question, namely being an example, give me an example where profit maximization wouldn't require healthy employees. Essentially, a company could function, maximize profits to the end, the most profits, gets the most profits by not having healthy employees, not doing anything. I mean, if any, like, just give me an example where a company, like, if anything, it kind of relies on people becoming unhealthy, maybe getting hurt in order to be profitable. So if you send me that example, I will excuse you from 2 discussion board posts. So if you've gotten all the way to the end of this video and you have a good example, you can email that to me. And yeah, just a little bit of a reflection. I am not going to even give you a word requirement on this, but it does have to be a full answer. It needs to be, you need to explain exactly why profits were able to be maximized in the absence of any sort of resources put into employee health, right? And then you will be excused from 2 discussion board post assignments, which is I think probably a pretty great deal, not a bad exchange. So yeah, thanks for getting all the way to the end of the video. Like I said, you can email that example to me. I don't even have a word requirement for it. It does need to be a full example though. So I think all of you are pretty familiar with my grading style at this point. If it's not a full answer, maybe I'll excuse you from 1 discussion board post. But yeah, good answers, full answers will be excused from 2 discussion board post assignments. And those would just be for the threads. You would still need to, nope, those would be for both the threads and the replies. It would be for the full DBA assignment. So for 2 of those. Okay, well, thank you again for getting to the end of the video. I hope that you thought about some things this module period that hadn't occurred to you before, and I will see you all next time.